Welcome, Small Biz Reorg. Purdue Pharma. It brings up emotion. It brings up questions. Everybody has a view on the Sacklers. But the real question isn't the Sacklers. The real question is what happens next. So there's a plan of reorganization on file in the bankruptcy court. That plan of reorganization is 158 pages. On top of that, we have a plan supplement that contains information related to that plan of reorganization that's 937 pages. And we have a disclosure statement that explains the plan of reorganization that's 510 pages. All of these were filed back in 2021, between June and September. And where does that leave us? That leaves us with an appeal that has reached the Supreme Court. So, for a case that started in 2019, we're now before the Supreme Court. But the question that's probably really important to most of you is, what happens? What happens when the Supreme Court rules? You've made it very clear you don't want the Supreme Court to let the Sacklers have releases. You don't want them to walk away paying the money that they're going to pay and being let off the hook, for lack of a better term, even though they're paying some $5 billion. Under this plan of reorganization, there's going to be a number of trusts created. Those trusts will go to fund certain state programs, to pay claimants, and for various other purposes. And the Sacklers will lose control of Purdue. If the Supreme Court reverses, the case goes back down, probably to the bankruptcy court, and litigation continues. What the bankruptcy court does, unclear. The court could do any one of a number of things. We'll discuss that at the end of the video. But we're lucky. We have joining us today Candice Kline, bankruptcy attorney and adjunct professor at the University of Toledo Law School. Candice was at the oral argument on the Purdue case and will give us her views as to the likely outcome. Please remember, nothing you hear today is legal advice. To obtain legal advice, you need to retain your own counsel and have them advise you. Thank you for being with us today, Candice. Candice, let's start with a topic that I know you are passionate about, third-party releases, more specifically non-consensual third-party releases, which seem to come up in many cases. Right now, before the United States Supreme Court, I guess we're all waiting for the court to come down in the Harrington case. I know you were at the court for the argument. Where do you think it's coming down?
I think that the Supreme Court will find it hard to read authority for non-consensual third-party releases into the bankruptcy code. There currently is a circuit court split on this issue. It is obviously a linchpin for large mass tort cases, but non-consensual third-party releases, which is essentially the release of claims between two non-debtors by a bankruptcy plan, that challenges the authority of the court on many levels, and it comes up a lot in Chapter 11 practice. So first level is, how does a bankruptcy court have authority over non-debtors for a direct claim by one non-debtor to another non-debtor? Nobody here in that circle of life have filed bankruptcy. So it's hard to see how a bankruptcy court, and therefore also a Chapter 11 plan, can even reach those claims. Another issue is the due process concerns around non-consensual third-party releases. In class action practice, it's typical to be able to opt out of giving a release or opt out from a settlement. Here, the bankruptcy court is requiring even non-consenting plaintiffs and claimants to agree to the settlement and the release of their claims. And that does seem a bit extraordinary. When you look at the statute, which here is the bankruptcy code, that's a little challenge too. So while there's some general equity language in the code, including in the provisions governing Chapter 11 plans, they don't seem to be anything other than residual sort of equity fluff, and that you need to have authority somewhere else in the code to grant these non-consensual third-party releases.
Well, Candice, let me back you up a little bit. Number one, hasn't this been going on for the last 25 or 30 years?
I think it's hard to find that. Only in a few circuits. So, yes, has it been going on for 30 years? But, it takes a long time. If you look at constitutional law, Roe v. Wade's a good example. That was the law for 30 years and now it's not, right? So, it takes a long time for constitutional type issues or circuit split issues to ultimately be decided at the Supreme Court. So, I don't think it's terribly meaningful that it was in place in New York and Delaware for 30 years. That's certainly not the case for the Ninth and the Fifth Circuit, for example.
Well, let's also talk about what we mean by third-party releases. If it's the officers and directors that are running the company during the bankruptcy, is it acceptable for them to be protected?
There's a concept of exculpation, which is essentially a release, and it's non-consensual in the sense that, it's in the plan. So if the plan's confirmed, they get released for their conduct and all of their professionals, their conduct during the case. Often these releases are written really quite broadly, maybe to reach every single employee of the debtor, which I've seen recently in a Delaware case. So yes, exculpation clauses, even though quite customary in Chapter 11 plans, I think would be subject to scrutiny after a decision by the Supreme Court that would bar or constrain the use of non-consensual third-party releases. Exculpations would clearly be challenged.
But don't we want to encourage reorganizations? Don't we want to encourage keeping these companies in business to maintain the employment, to avoid liquidations?
Well, I would say one, are they even necessary? So I'm not sure that they're necessary. People get paid to do this work. They also carry insurance. So, I believe that there's always a market around risk management, and that would be here too.
I guess that's an open question that we'll have to see as we go forward. Next question, I guess, is would there be an alternative? If there weren't these releases, would we see as many bankruptcies? Do you think that it would discourage the filing of bankruptcies if a board of directors realized they wouldn't be getting a release?
Potentially. The board obviously is making decisions. They're also making decisions ideally on behalf of the debtor and not personally. Sometimes bankruptcies cannot be avoided, right? Because of an insolvency or, external factors. That's in part what these mass tort cases are about, are external factors, not at all related to solvency or insolvency, but a tactic in order to remove litigation as a threat to the company, right? So mass tort, the claims can get quite numerous. They can be large. It's tedious to go through litigating torts in our court system. Sometimes you win, sometimes you lose. You might lose spectacularly. So there is a great desire to try to have a solution that at least looks like these bankruptcy mass tort cases, but may or may not be using bankruptcy courts as they have been attempted today.
Right. And of course, you're referring to Section 524G with the mass tort cases. But let's go to, you're a law professor. One of my favorite sayings, and on this channel, we tend to stay more lighthearted: bad facts make bad law. We've all seen the shows about the Sacklers. And of course, the Harrington case deals with Purdue. And there probably has not been many more hours spent on any family than the Sacklers, at least not in recent times. Docudramas, miniseries, bad facts make bad law. That's the case that's been brought up. And now we're going to have law based on that case. Isn't it possible that this is going to be bad law?
Well, I would say the Supreme Court often hears the most egregious cases, right? Because they want a clear shot at the issue. And yeah, it's unfortunate that there has been a plan proposed that releases the Sacklers for their $5.5 billion of contribution. They're basically buying a release. They're buying global peace. And we have a system and a Chapter 11 plan today that is enabling that. My concern is that even if this is say, a practical solution to get money to opioid victims today, I do have concerns that, one, not everyone is on board with this approach. They should have had a right to opt out, play their game as they would like, to pursue their own claims or not, just to get their day in court. I mean, that's the due process concern. My other issue is that the Sacklers prevail, then everybody prevails. And so that means, it doesn't have to even be a family as controversial as the Sacklers, but it could be every parent company, right? Avoiding the liabilities of a subsidiary that they created specifically for the purposes of discharging mass tort liability in a bankruptcy case. Another situation would be, for example, Catholic diocese, right? Again, these are significant abuse cases. They are all over the place, coast to coast. And, the bankruptcies are devised to limit the amount of property that is contributed to a settlement. So, one thing that does seem to be a bit of a challenge with these bankruptcy cases is that it does give a lot of leverage to a party like the Sacklers, or say the parent company, Johnson and Johnson, and their subsidiary LTL and their talc liability suits, Boy Scouts of America, all of them are using the bankruptcy tactic to enable, enforce, compel, these are strong words, a settlement at what I would argue is the lowest dollar value, and gives a lot of influence to the debtors to protect property that they want to protect from these plaintiffs and the plaintiff lawsuits. It may be well-meaning. For example, with Johnson and Johnson, they want to protect shareholder value. So, many of us are shareholders of Johnson and Johnson, right? And so that sounds like a noble cause. But generally, I think there is an issue, which is with all the leverage on the debtor side, that they're running the game, and that erodes public confidence and trust in our bankruptcy system.
Well, I agree with you that there's a lot of problems with public trust, but let's unpack a little bit of what you said there. Number one, the public also wants recoveries. And let's step back to the Sacklers, where there's money in trusts, and we know that was a problem in that case. So let's stay there. And there looked like there was going to be a problem getting money out of those trusts. And a negotiated settlement that's voted on by the creditors and meets the standards of the bankruptcy code and is overwhelmingly accepted by the creditors, shouldn't that plan be allowed to go forward? Boy Scouts, same situation. The creditors vote in favor of it, so the minority is opposed to it. Candice, we have situations where you have plans that have been voted on by the creditors. The majority, following the rules under the bankruptcy code, has voted in favor of the plan, following the rules of the bankruptcy code. They want a recovery. In certain situations, you may have elderly people, and they want a recovery now, not after 2 years, 3 years, 5 years, 7 years of litigation. Shouldn't they be allowed to get that recovery today, as opposed to having somebody chase, let's say, the Sacklers all over the world, possibly squandering whatever money there is as they pursue what may never happen, a recovery by chasing trusts overseas, or in other cases, pursuing what's a fanciful recovery. We all know legal fees can run up very fast in these cases, and you can spend what most people would consider a fortune pursuing recoveries. On the other hand, through the bankruptcy process, you have a recovery. Isn't this a bird in the hand is worth two in the bush? And by taking this approach, what you're actually doing is allowing the minority to dictate what's going to happen, and you may never get a settlement because the bankruptcy process does foster that settlement?
No, 3M, which had a similar strategy with Aero Technologies, has come up with a private settlement mechanism through their MDL, which is multi-district litigation. And so I think that there are a lot of other alternatives, the 9/11 Fund, Deepwater Horizon. The Sacklers could have done something similar to that. You don't have to use bankruptcy. All of these examples, by the way, are outside of 524G, which specifically mentions asbestos and is, I think probably vulnerable to whatever the Supreme Court says about third party releases. And that was the one place where Congress said it is okay in asbestos cases to create a trust and then implement a channeling injunction such that all current and future claimants must go through that trust in order to get any kind of recovery. So there are very practical reasons to have this kind of tort settlement mechanism. The issue of plan voting, that's one, people who voted for the plan. So you do see supermajority numbers in terms of the classes voting for the plan, but that's amongst people who voted. And then the other issue of collectability, I don't know, in practical language around litigation, you will consider collectability after you get a judgment, right? And so to put on the table, hey, this settlement is the best possible because we're making all kinds of conclusions around collectability. I'm not sure that that even should come into play when you're thinking about liability and the justification for the non-consensual releases, where you're looking for, substantial contribution. I mean, there's all kinds of other factors that courts have looked at. But, collectability and alternatives, I mean, that tends not to be one of them. And it could certainly be the case that a plaintiff would want to go chase this and really test the law, and they might come up with nothing. So why should they be cut off by a Chapter 11 plan? There is a standard in the Sixth Circuit. It's under Dow Corning. And there, the non-consensual third-party release can be part of a plan just so long as plaintiffs are left with an opportunity to seek a full recovery elsewhere. Ultimately, that probably means an opt-out plan. The Sacklers have a ton of leverage right now saying, oh, it's all or nothing. You give us the release or we're out of here, and we require a complete and comprehensive release, something that they couldn't get in all circuits in the country today. That's a lot of leverage to say all or nothing. I think they would probably settle for 99% of all claims and let a few dwindle on. It's not that much money, really, to try to litigate a few straggler claims. And if you're so confident in those Jersey trusts and everything else that they did for asset protection, then what's the liability? So what if you have, say, 30 or even 300 cases continue? I don't see it as something that would make them walk away from a pretty comprehensive settlement with most claimants in all states.
So your feeling is Supreme Court comes down, third-party releases are severely restricted, and we'll see where bankruptcy proceeds from there.
Yeah, I think so. And we have plenty of models. And today there are successful cases that use opt-out in their ballots, and there's still settlement cases, and they seem to be fine. So I feel like it's maybe not the sky is falling, that, we are in a creative profession, and, we will find our way.
Well, I'm going to thank our guest, Candice Kline. As you can tell, there are a number of different views as to where the Supreme Court is likely to come out and what the effects are going to be of this ruling. What is certain is that the impact will be real. If the plan goes forward, there'll be funding that will go not only to individuals but to states and to agencies, and that funding will be rather immediate. If the Supreme Court overrules the Second Circuit and reverses the decision, the case is going to be remanded, whether it goes to the district court or to the bankruptcy court. The plan will have to be changed materially, and it'll take time, potentially significant amounts of time. And it's unclear whether or not an agreement can be reached with the Sacklers, with Purdue, and what will happen. What is clear is that it probably will not be a fast process. And those who expected to receive funding quickly from the settlement with Purdue will be waiting. And they've already been waiting for a long period of time. And those people, those who have suffered through this opioid crisis unfairly, will continue to suffer. And that is the true tragedy of what we're discussing, is the human impact of this case. I'm Jack Rose of Small Biz Reorg. If you found this helpful, subscribe, ring the bell. We'll be back when the decision comes down. Hopefully Candice will join us and we can discuss exactly what the impact is of that decision from the Supreme Court.